You're listening to the JS Held Podcast Network, where trusted advisors share insights that shape industries.
Hello and welcome to JS Held's new podcast, From Variables to Verdict, a podcast which takes recent case law and considers the role of factual evidence and expert analysis in shaping the judgment.
And for our inaugural podcast, I'm particularly excited to be joined by James Phantom from Keating Chambers. James specialises in international arbitrations of large value, including construction, energy projects, and procurement. I'm also joined by Lucy Pearson from King & Spalding. Lucy is said to be involved with high-value bet-the-company disputes involving engineering infrastructure projects around the world. Now, to introduce our very first case to be explored in this first podcast, I'm going to hand over to Lucy.
We're going to be talking today about the case of Pawtucket-Philly against Woodward Fisher. Now, this was a case that appeared last year before the Property, Trust and Probate list in the High Court, and the judgment of Mr. Justice Fancourt was handed down in February of this year. Now, it's an unusual case, to say the least, and that was actually acknowledged by the judge in the final paragraph of the judgment, where he refers to it as an extreme case. The judgment certainly made for a very interesting read, although I have to say that I did feel quite itchy whilst reading it, and I'm certainly going to check my wine glasses for moths before I next use them.
I think staying with the theme though of evidence, the most important lesson we should learn from this is not to check the wine glass for moths, but to then photograph your wine glass if you find a moth.
And your toothbrushes.
And your toothbrushes. Let's not forget toothbrushes. Although we'll come on to those questions of wine and toothbrushes, I'm sure.
Absolutely.
Later on in this podcast.
Absolutely. So this is a case that received quite a bit of attention in the mainstream media in the UK for a few different reasons. So firstly, the case centres on an issue which, for anyone who's ever bought a house, is perhaps one of their worst nightmares. As I was reading this case, I was picturing my sister who hates insects, spiders, moths, and trying to think how she would act in this situation. And I think the answer is not very well. Secondly, this case is very much a reminder of the extreme consequences which can result from a successful claim under English law for fraudulent misrepresentation. And last but not least, and perhaps most relevant to our conversation today, the case has some important commentary with respect to the use of expert evidence in court proceedings, and very much highlights the court's willingness to scrutinize expert testimony and reject evidence that lacks credibility or a proper foundation. So what was this case about? Well, the Moth Case, as it has been dubbed by the media, involves the buyers of a house successfully bringing a claim against the seller of said house for failing to disclose a severe moth infestation, resulting in rescission of the sale and allowing for the immediate return of the house subject to an equitable lien for repayment. Now, this wasn't any old house. It was a luxury mansion in one of my favourite areas of London, Notting Hill, purchased for £32.5 million in 2019. Now, shortly after moving in, the buyers discovered a severe infestation of clothes moths. They reported seeing up to 35 moths per day in the house and finding them on towels and on their children's toothbrushes. They also reported, and this made me shiver when I read it, that moths would fly into their faces as they walked around the house. The infestation persisted despite treatments, which they spent upwards of £300,000 on. And following investigations, the infestation was traced to natural wool insulation, which was used during renovations by the defendant, who had undertaken a large renovation of the property before he had sold it to the claimants. It later transpired that prior to the sale, the defendant's wife had become aware of the problem with the clothes moths in the property, and various pest control treatments had been carried out. The defendant had, or his wife had, at least 2 reports from pest control companies which stated the need to remove the insulation in order to get rid of the infestation. Now, during this time, the defendant was discreetly marketing the property for sale, and the claimants ultimately made an offer and purchased the property. During the purchase, the defendant had answered pre-contract inquiries denying knowledge of any infestation, defects, or pest control issues. And as such, the claimants brought a claim seeking rescission of the contract and damages and alleging fraudulent misrepresentation by the seller. Now, the key issues for the court in deciding this case were, in terms of the misrep, were the defendant's replies to 3 of the pre-contract inquiries misrepresentations? Did the claimants know of and rely on these replies? And did the defendant know the replies were untrue? In terms of the rescission, the court looked at 1, are the claimants entitled in principle to rescission? 2, does the court have discretion to refuse rescission? 3, does the defendant have a defense to rescission? 4, what damages are recoverable if rescission is granted? And 5, what damages would be recoverable if rescission were refused?
Before we move on to look at the causation issues, it's helpful to, I think, to focus particularly on what are the legal issues which arise on the misrep and the detail of them. In the normal way, the misrep was said to arise from the typical inquiries and responses between the parties' solicitors during the sale. And there were 3 inquiries and responses which the court was asked to consider and which the claimants said were false. Firstly, it was asked, has the property ever been affected by various things, including vermin infestation? The answer to that was that the seller is not aware of any such matter, but said the property had not been surveyed for such matters. The second question was, please supply a copy of any report concerning any matter referred to in the first inquiry, or otherwise concerning the fabric of the property. The response to that was that, save as has been disclosed in the documentation provided, there are none, i.e. no reports. The third question was, is the seller aware of any defects in the property which are not apparent on inspection? And then in brackets, due to the presence of furniture, carpets, cupboards, etc. The response to that was the seller is not aware of any such defects, but has not had the property surveyed for any, so no warranty can be given. And so the court's first issue was to go through whether each of these were false, and various different arguments were raised by the defendant as to why it was said each one was not false. So to look at the first inquiry response, the starting point was the response was actually a statement of knowledge. The seller is not aware, rather than a statement of fact, i.e. it did not say there is no vermin infestation. But it was said to be false because of the moth infestation. So the first issue was, are insects generally, and moths specifically, vermin? After quite an interesting discussion of dictionary usage of vermin, insects and moth, but also, thankfully, some common sense, the judge said yes, moths would fall in with what you would typically count as vermin in this context. The second issue was whether there was an infestation. That was not seriously disputed, and the judge said yes, there was. As Lucy said, it was quite an extreme set of facts. It wasn't just kind of finding one moth on your favourite suit at the back of your wardrobe. The third issue was that, as I explained earlier, the reply focused on the defendant's knowledge. So to be false, it had to be shown that the defendant knew, or at least suspected, there had been an infestation of moths. And the judge said on the evidence that was the case.
This starts where the evidential points of this case start to really come out, because it was held all the way through, not held, so it was advanced all the way through by the defendants that there was no knowledge that this was false, and that reports that had been provided to Mrs. Woodford Fisher had not been read, had not been understood by Mr. Woodford Fisher, and therefore could not have been misrepresentation in those replies.
And you can see that the court struggled struggled with that suggestion, and particularly there were the fact that these documents had been obtained, and the court said, well, you would have looked at them, and also there was because of when you were coming to these replies, you're being asked these specific questions. You should have thought about, or you have obtained these reports, even quotes. As kind of they obviously were aware, or at least suspected there was an issue, and they were taking steps to find out about it. So the court, although that was the case advanced, the judge clearly struggled with that part of the evidence, and generally seemed to struggle with the evidence from Mr. Woodward Fisher, and found him to be an unconvincing witness.
I thought one of the interesting points in relation to that question of being unconvincing and the evidence given was that there's an email that gets referenced which is sent at slightly past 8 o'clock at night, and there's nothing in the email apart from the report being forwarded on. And the inference that gets drawn by the court is the suggestion they were potentially sat on the sofa next to each other, and therefore no more introduction was required in the email than simply forwarding it on, and it would have then been read and understood by Mr. Woodward Fisher, which ultimately then comes to the point where the finding is that the evidence put forward was unconvincing, that there was no knowledge and would not have been aware of the contents of these reports.
I also found that section to be interesting, and I think particularly in the respect that I don't think any evidence was put forward, or I don't think the defendant denied that he was sat next to his wife as that email came in, and so the court made a sensible assumption there.
Yes, which is very much a question. I think this comes out all the way through this judgment. This overlaying of common sense of what would actually likely have happened in reality, over the top of sometimes very conflicting evidence from the witnesses, both witnesses of fact and witnesses of expert witnesses.
And the other point is that on some of the elements, in an unpromising sign for the defendant, his evidence as to what he was told by his solicitor conflicted with his solicitor's evidence as to what advice he gave. So you can see that clearly, they seem to be wanting to run various different cases of saying, well, we knew there was some moths, or we didn't believe there was an infestation, but we didn't think it was vermin. So I think it's a typical situation often where if you run every single point, which rather seemed to be the approach the defendant was adopting, there comes a point where the court has enough, and often says, well, that can't be right, but B, also you lose credibility in terms of the witness evidence, but also the legal arguments you're putting forward to the court. So I think there's a lesson there as you should never view it that running a bad point could be done, but just because, well, have a go, what's the worst that can happen? We still have our other good points, because there's always the risk that actually those bad points do infect the rest of your case because they prejudice the decision maker against you on those other points.
I think particularly where you then have factual evidence that runs contrary to what's been advanced. So the idea that, and we'll come to this in a second, but the idea that the reports were not trustworthy and therefore the information in them weren't believed, and because of this they weren't actually presenting misrepresentation in the replies, run slightly counter to the fact that there's emails saying, we like this last inspector that came, we want you to do more work, but we want a discount, is very contrary to we thought it was all lies, we don't believe it.
Yes, I think the judge refers in his judgment later on to, why would you be seeking a discount and seeking to engage them for further services if you had no faith in their services and you thought they were rubbish, essentially.
A key part of that was that all three inquiries went together, and the judge looked at particularly the response to the first inquiry, in the context of the responses to the second and third inquiries. Because to move on to them, the second inquiry was a simple statement of fact to provide a copy of any report concerning a matter referred to in 2.1 above, or otherwise concerning the fabric of the property. And the factual answer was, there are none other than what had been provided, and the documents which had been provided weren't the relevant documents. In response to that, the defendant raised two legal arguments. Firstly, it said, well, the documents we have, one, for example, was a quote which identified the issues, weren't reports which would fall within 2.2. And the court made short shrift of that, saying it's not said to be, it wouldn't be understood as limited to very formal reports, and a report, the judge said, is no more in this context than a document that reports on a vermin infestation or on the fabric of the house. And the second issue was, well, because of the reference to fabric of the house, is insulation in the internal walls and floorboards part of the fabric of the property? And the court held it was. And a key part of the court's reasoning was this wasn't a case with the defendant, because the defendant was trying to say, well, look, we didn't realise these would be viewed as reports, we didn't realise these would be viewed as vermin infestation. But where the court really struggled was in fact what had happened was the defendant hadn't provided these documents to his solicitor. It wasn't a situation where he'd said to his solicitor, okay, well, I've got these, do you think these meet the test? Or do you think these respond to the inquiry? He had held them back. And you can see that's where the court's suspicions came in. And once the court finds, well, you deliberately held back these reports, that inevitably influenced the court's assessment of the other issues. Because, okay, well, why are you holding them back? And then is it because you are, in fact, aware of their other issues, or at least you're being reckless to finding out whether there are, in fact, issues in terms of the moth infestation. So that's the second inquiry. The third inquiry was a statement the seller was not aware of any defects in the property which are not apparent on inspection. Again, it was a factual statement. The claimant said it was false as the infestation of the insulation was a defect. And the defendant's position, again, largely raising any and all points it could think of. Firstly, it said the infestation is not a defect. Secondly, it said that the nature of defect the inquiry sought to cover was defects covered by chattels, picking up on the bracket saying due to the presence of furniture, carpets, cupboards, etc., after saying it, which are not apparent. And both of those were rejected by the court. And unsurprisingly, I'd say, because none of that is found in the simple and ordinary language used. It was any defects which are not apparent, and the brackets aren't seeking to limit that. They're examples. So on that basis, the court decided it was obviously the response was the seller is not aware, but the court, as we've already discussed, had found they were aware of facts, which meant that reply was false. Just very briefly in terms of the other issues, so once the courts, because this was claiming tort of deceit, the court found that the three inquiries responses were false representations, but just dealing briefly with the other elements, there had to be reliance by the claimant. The point made here was the claimant had never directly read the inquiries, but crucially the solicitors and other agents acting for it had knowledge of them, and the court said it informed the advice they gave when the claimants purchased the property, and that was sufficient reliance. The next element, fraud, of course, requires dishonesty, and the court said, well, they knew the second and third inquiries were false because they knew there were reports and they knew there were defects. And then they were at least reckless as to whether there was a moth infestation. And that, as I said earlier, was the key point, was the fact that they hadn't informed the solicitor of the reports. It was reckless, the judge said, not to say to your solicitor, okay, well, we've got these reports. Do these show a vermin infestation? And having found then in the tort of deceit, as Lucy explained earlier, the court went on to decide that the contract should be rescinded. So there was, in fact, no diminution in value claim. There was rescission and the certain costs to do the sale, such as stamp duty and so on. But for our purposes, in terms of causation, I guess where we can now draw the most interest is, in fact, to the court's opposite statements, to saying, well, if I hadn't have rescinded, what would it be in the diminution in value I would have found had been suffered?
Just before we go on to the question about the diminution in value and how you assess the damages and the losses, that was the obiter from this particular judgment. I think staying with that earlier theme of just how much common sense and practical law flows through this case, it's maybe worth just very briefly looking at the actual award that was made, because we had the contracts been rescinded and we know that the property was purchased for £32.5 million. Now, putting that into context, when the house was originally purchased by Mr. Woodward Fisher, it was purchased for 10.4 million and then had £10 million spent on it in terms of the extension and the renovation of the house. and there was a loan or a mortgage taken out for approximately 17.6 million. Now, at the point at which we have the judgment, the court finds that Mr. Woodward Fisher has insufficient money to actually buy this house back. So we're not able to put the parties necessarily in the traditional sense of the word back into position they would have been if this contract had not happened, because we can't give 32.5 million to the claimants in exchange for the house being transferred in title to the defendants. So instead there's this pragmatic solution that seems to be taken forward, which is the house is then to be put into a position that it could be sold at the expense and by Mr. Woodward Fisher with a lien on it from the claimant. There's a subtraction from the sums due to the claimant upon the sale of the house for the enjoyment and the value of enjoyment they had for the years they were in the house. And then there's damages to be paid, again, for additional damages suffered in that period of being in that property. So we have a situation where the defendant couldn't afford to pay the award had the traditional award been made, but there's a very pragmatic solution through this.
I think that's right. And obviously the court, I think, reached that view because the judge decided as a matter of law that the arguments the defendant was raising as to why it's saying, well, you shouldn't order rescission because we can't pay, couldn't be relied on, because the court found that there is no, once you find fraud, there's no discretion to refuse rescission. There are certain established bars to a claim for rescission, but it's not a bar that the defendant says, well, I can't perform or give back what I've received. So because of that, the court had to rescind. But you can see that in that scenario, the court was keen to at least have justice and some equity. And I think that's what led the court to adopt those kind of practical measures. And the judge used the phrase practical justice.
And again, just staying back to the focus here of the evidence, along the way, in addition to the contract being rescinded, there were claims for damages that were brought, even where it is found that the contract effectively gets unwound, and that was including things like, for example, the clothes. I think the clothes is just an interesting point to pick up on in terms of the evidence, because the original assessment of damaged clothing was £7,500. This then increases during the case, and the final figure is £50,000. So we've gone from £7,500 to £50,000 of damaged clothes due to infestation of moths. And this is supported by 4 photographs. And off the back of the 4 photographs, which on first kind of review doesn't seem very much, that there is actually an award made of £15,000. So it's a £15,000 damages claim based on 4 photographs, which evidentially I thought was quite interesting.
So did I. And I think the judge noted in his judgment that he was surprised that the claimants hadn't taken photographs to further evidence as part of their claim. It seemed that in ultimately reaching 15,000, he was seeking to strike a middle ground between the 50,000 eventually claimed and the fact that they hadn't provided evidence to substantiate adequately, arguably, such a large figure.
Yes, and that comes up in a lot of these kind of claims from the claimant. The fact that we spoke earlier on, that part of it was discussing the often described onerous situation which the claimants are living under, with killing up to 35 moths a day, having moths in the wine glasses, on the toothbrushes. But the judge recognises that there was no witness evidence from any friends. There was no photographs of moths in wine glasses, and for all of this conversation, there was actually quite a absence of supporting evidence where it would be very easy to have evidence.
Absolutely. And I think in this part of the judgment, the judge doesn't seem to provide any other reason as to why, had the claimants provided photographs and receipts of £50,000 worth of clothes, they would have been able to recover that figure. So it really highlights how important it is to properly substantiate your claim with the right records and photographs and receipts where you can.
Yes.
I mean, you do wonder if the judge may have been influenced by seeing Mr. and Mrs. the claimants turn up in very nice clothing during the trial and thinking, well, it's obvious they have nice clothes. But also, I think there was their own bespoke wardrobe for £50,000. So you presume you're filling that with nice clothing.
Of
but
course.
I think the broader lesson is probably that it's often, if there had just been a case, say in the county court for £15,000, you would probably have applied a higher standard of evidence. But because, even though this is in the High Court, because it's just a small part of a much bigger case, and we often see this with arbitrations, that it gets to a point now where maybe previously the court would go through every single line item. You just can't do that. So tribunals and judges are more willing, I guess, to be reasonable and pragmatic and think, well, okay, I accept, given the moths, there must have been damage to clothes. I accept you would have had relatively extensive and expensive clothes, so I'm going to do the best I can and come up with a figure. Which as a claimant is probably is a good thing, that you are seeing more of that flexibility and not kind of a strict application of burden of proof, which means the figure is nil.
So taking that as that point and then moving forward, of course, we know what the outcome of the judgment is, but we then have this quite a large section at the end of the judgment where it seems to follow along the lines of, I've made my decision, but it might be useful in the future if I gave my opinion what it would have, my judgment what it would have been had we now awarded damages rather than the route where we've gone down. And from there, the assessment is actually looking at what is the diminution in value and what is going to be the cost and the loss to the parties as a result of this moth infestation. And there has been quite a lot of discussion already in the press in relation to this closing section of the judgment, largely because the figures become so, not quite shocking, but there's a vast disparity between the opinions of experts that get expressed in this case. And on one hand, we have an assessment which is 8.5 or just 8.4 million for dealing with the issue of the moth infestation. And at the start of the court case, we have an opposing valuation which is 160,000, which is a staggering difference in opinion to derive from experts on a house that has been purchased for 32 million. So that we got a third of the cost of the house, which is similar to the entire amount spent in the initial refurbishment, the extension, which is a 200% extension in the house, on the one hand, and on the other hand, a valuation which is, for a £32 million pound house, frankly, quite low.
Yeah, I have to say I found the judgment particularly interesting at this part and at times quite scathing of the expert's approach. I think having read both sides, both the claimant's expert's position and the defendant's expert's position, and then read the judge's conclusion, it's very much an example of the court preferring, again, common sense and a real life practicality rather than very extreme examples.
So just to put this into context then in relation to the reason for these two valuations is that on the one hand, the valuation is based on the idea that once the works have been done, there cannot be any shred of material left in this property that could at any point house a moth. So I think the slightly flippant description from the claimants was rip the walls down and rebuild it.
Yes.
On the other extreme, though, is we have a series of drawings that are alleged to be as-built, but in truth are generated many years after the works were done during the court case to show where the insulation material was located in the property. And the approach of the other expert is we're going to open up those sections only, remove the insulation where we find it, and then put back synthetic insulation and redo the petitions and redo the walls. So a very, very limited scope of work. And of course, the judge ultimately turns around and says they're both wrong.
Yeah, I think he explains that both approaches have limitations, and taking each in turn, the claimant's expert's approach, which, as you say, he was instructed to devise his scheme on the basis that it would eradicate, I think, all moths from the property. And one of the points that's made at various points of this judgment is no home in London, or to be very unlikely to find a home in London that has zero moths, and so it's not a realistic standard on which to base your approach. And I think his scheme, involves removing all internal plasterboard, all insulation throughout the house, on internal walls and ceilings, and guarantee that those spaces contain absolutely no presence of either type of wool insulation that was used in the property. He used at one point in his evidence the word guarantee, in the sense that it would guarantee that there was 100% removal of insulation and the subsequent infestation. And his approach led to an extremely expensive and extensive scenario. And I think when you read that alongside the defendant's expert's approach, which, as you say, was based on some drawings he'd received from the defendant, which the source of those drawings and the date of those drawings was unclear, and perhaps hadn't been adequately interrogated, arguably.
Well, I think it went further than that. It was found that they were just plainly wrong.
Yes. Yeah. Well, I think at trial and before the court, it was easily proven that the drawings produced by the defendant, which had labelled insulation at certain points in the house, were incorrect. And I think the claimant had said in evidence, actually, you've shown that the insulation is there, but it wasn't. And that very quickly undermined the credibility of the defendant's expert evidence.
I think the other point to bear in mind, of course, is that although it very much reads as the court assessing expert evidence for the cost of a reasonable remedial scheme, which is effectively the evidence put before the court, the actual question for the court was, what's the diminished in value? Now, in those cases, that is, it's what was the price you paid versus what was the market value in the current condition. Now, of course, the starting point to assess that is a remedial cost, because you could say, well, look, if this house is free of defects, it would cost 10 million. Because you need to do £3 million worth of remedial works, you would turn up and say, well, okay, it's worth 7 because take off the 3. But you can see that that's not the complete answer or the only answer, and that's why the court was adopting a more practical position, because as the judge said, that's what a buyer would have done. If you turned up to buy it, you wouldn't have said, okay, well, I buy this house, I need to go in and spend £7 million eradicating a moth infestation, completely guaranteeing there can never be any moth again. And the court had very grave doubts as to whether, if they were going to stay in the house, the claimants would have done that. Not least given their own evidence as to how fed up they were with the house. So that does allow the court to adopt a more practical view than a pure kind of quantify the remedial scheme approach might have done.
So bringing back then to the question, because when you read the judgment, it's not always clear, although I think we do use the words instruction a few times today, but it's not always clear how much these schemes were devised by the experts and how much these schemes were instructed by the solicitors. And ultimately, the court didn't like any of the schemes and started with one of the experts' evaluations, then built it up, but didn't actually use either of the schemes that had been put forward and devised his own solution. How much is there an obligation, do you think? How much more it would assist courts if there was greater alignment of instruction between experts to make sure that the schemes being presented were aligned rather than being ships passing in the night?
I mean, I think it's a good question. I mean, I think it's right that it does seem, although criticism may appear to be directed at the experts, probably it's more the legal teams who set, basically, it's the exam paper they were each set, which was more the problem than the answers given to the exam paper. And particularly, these are quantum experts who wouldn't normally be in their remit to design the scope of the scheme. They're effectively quantifying it. I think the starting point when you have a case like this is you would of course want both experts to give alternative assessments of each other's schemes, and they did try to do that. At least the claimant's expert did try and give a figure for the defendant's scheme, which the court referred to. But it does show that there can be the gap which can emerge is if the court says, well, no, neither of these are the right schemes, and there's a middle way. And of course, that's where there is a problem, that's not a scheme which the experts had valued. I mean, it's interesting, the court did say, well, there were two options open to the judge: one, to do the best he could and value his scheme, or two, to have the experts have another look. And although he adopted the do the best I can, I wonder if he hadn't have found rescission and this was actually going to be his award, I wonder if he would have said, okay, no, actually, we need to have the experts look at this again. But otherwise, I mean, one thing the parties may have wanted to consider is once they realised how disparate their positions were, it could have been one where maybe a preliminary issue could have been listed for the court to decide what's the scheme, and then you can go away and cost it up. Of course, the downside to that is a key factor in which is the right scheme would have been the cost, because the court may have had a different view on the claimant, inevitably had a different view on the claimant scheme, given how much it cost. That was a key factor in why that wasn't reasonable.
I think this case makes for an important read for both kind of solicitors, barristers and experts alike. Firstly, in respect to the importance of independence of expert evidence. It particularly with regards to the defendant's drawings and the fact that the defendant's expert witness based a lot of his evidence on those drawings, it emphasized that experts must challenge assumptions given by their instructing party. Where they're given a document, they must ask, what is this document? How has it been created? When has it been created? And failing to do so, they perhaps open themselves up to criticism by the court or the tribunal. They should ensure that they're using accurate and verified data, as opposed to documents which have been produced primarily for the purposes of litigation. And going to the point that we've just discussed, I think they should be open to reasonable concessions, during proceedings. I think the case also highlighted that instructions to experts matter. I think, as we've discussed, the experts were given very different instructions to this case. And the court was very critical of both extremes, and ultimately reached a practical middle ground. And so this emphasizes the importance of giving realistic instructions to your experts. I think the emails highlighted by the judge were pivotal in proving fraudulent misrepresentation. And it showed that sometimes internal communications, reports and advice can form a key part of a party's evidence in a case. It showed that courts can be willing to dissect expert evidence, and they're not always passive when it comes to expert reports, and are very much willing to question the basis on which experts have formed their conclusions. It also, and perhaps not as relevant to our day jobs, it shows the importance of sellers giving truthful and complete answers to pre-contract inquiries, and what can happen where they don't.
Yes, I think that is a very good summary of the overall case. And we've mentioned this a couple of times, overarching all of that is the level of common sense testing of the evidence that was put forward, and some very pragmatic solutions to the situation that the court found itself in.
I think that's right. I think it's also a lesson that if you want to bear in mind that when you're presenting your case for a court, if you only present extreme positions, that can be a very difficult position for the court to adopt. And always have in mind that if you do have what seems like an extreme position, particularly compared to the other party, that you may want to bear in mind whether you want to have what could be viewed as a more reasonable alternative for the court to look at. Now, sometimes people want to kind of bet the house and think, well, if I provide the reasonable alternative, of course, the tribunal or judge, he or she may go for that. So I'd rather kind of push my extreme case. But you can see that in this case, it may have been helpful to have thought about and provided a lesser scheme, because it may have been the claimant, if that had been the award, could have got to a bigger figure than the better figure than what the judge got to on his lesser scope. I think the other key, I do agree with Lucy, that a key lesson is instructions on many angles. One, it's a key part of the expert evidence, and a key way they can be undermined is it's not necessarily challenging the expert's opinion, but it's challenging the instructions or the assumptions on which the opinion is based. And that's particularly, I think, can arise in quantum, where inevitably the quantum expert has to rely on what he or she is told by the liability experts or the client as to what scheme to assess. But I think there's also a lesson here that an expert, given their duties to the court, it's probably not good enough just to say, well, this is what I was instructed to do. Because you can see, I think, in the judgment, the court even if not expressly, having some difficulty with the experts kind of accepting that that was their role, their instructions, and not challenging, saying, well, is that right? I think I should be providing an alternative, or can I just check that that is the right scheme? So I think that's something to learn for experts, but also their legal teams, is to make sure you're protecting your expert in that way, but also you're providing helpful evidence to the court. And you can see that in kind of a way which is all now too familiar, that often when you have such big cases and so many issues, the court's decision as to which expert they find more persuasive can often just lead to the dominoes all falling in that way where they disagree, because it's an easy thing for the judges to do, but also it's a sensible and rational thing. They'll have heard both experts over a couple of days, and rather than then on each individual issue say, okay, who's right or wrong, they may just say, well, I prefer X because I found X more credible. And that was what the judge said in this case.
And upon that rather extreme health warning, thank you so much, Lucy and James. It's been a pleasure having you on today. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you for listening to From Variables to Verdict. Join us next time as we continue exploring how evidence and expert insight shape outcomes. If you enjoyed this episode, subscribe on Apple Podcasts or Spotify.
To learn more about our expertise or connect with our team, visit jsheld.com and subscribe for future episodes. JS Held. Find your expert.